Good morning, and thank you for joining the UVA Clubs program and Office of Gift Planning today for a conversation on Estate Planning 101 with Skip Fox, a 1980 graduate of the University of Virginia School of Law. My name is Heather Engel, and I am the Associate Vice President for Gift Planning here at the university. Our technical team has given me a few housekeeping notes to go over with you before we get started. Please note that this event is being recorded and closed captioning is available. If you have any questions that you would like to submit, you can use the Q&A function while our speaker is talking. I'd also like to let you know that we've had over 1,000 people register for this event today, and many have submitted questions ahead of time. So we do have a lot of questions already. We will do our best to get to as many of those questions as we possibly can. With that, I'd like to tell you a little bit about Skip Fox. We are so lucky to have Skip here with us today. Skip is the former chair of McGuireWoods Tax Department and Private Wealth Services Group, where his practice focuses on estate planning, trust and estate administration, and charitable organizations. He is a fellow and past president of the American College of Trust and Estate Counsel. He is an adjunct professor at the University of Virginia School of Law. Skip has written or co-written 7 books and numerous articles and has been peer described in Chambers and Partners High Net Worth Guide as the voice of authority in the private wealth community. Skip lectures annually around the country at seminars on estate planning and trust administration, and he serves on the board of several charities, including the University of Virginia Law School Foundation and the Episcopal High School of Virginia. Most importantly, however, his father, grandfather, great-grandfather were all graduates of the university, and his great-great-grandfather taught at the university. Skip, with that, I will turn it over to you.
Thank you very much, Heather, and good afternoon. Please bear with me as I share my screen and pull up the PowerPoint. There we go, and hopefully everybody can see it and it's working well. What we're going to be talking about today, very briefly and from a very high altitude, is one of the most important questions that individuals and families often have to deal with. And that is how to plan for the disposition of an individual's assets during life and at death. So when we talk about Estate Planning 101, and I seem to be having a little bit of a problem, let's see, getting the slides to advance. There we go. When we talk about estate planning, there really is a working definition with which we all should be familiar with for purposes of this presentation. And that is, you're really looking at 2 things. One is planning for the transfer, as I said earlier, of an individual's assets to the recipients that he or she desires, either during life or at death. And that's very important because we all like to see our assets go where we'd like them to be. A second question is minimizing any taxes on those transfers during life or at death, because federal and state governments often do impose taxes on transfers. We'll talk about some of those in a few minutes. But the most important thing is, where do you want your property to go? To whom do you want it to go? And how do you want it to go? And you worry about taxes after that. All too often when you sometimes meet with financial planners or lawyers, whoever, they start talking about minimizing taxes first. And before you do that, you've really got to decide what you want to do with your property, because taxes should only be a secondary consideration. Another way of looking at this is you simply don't want the tax tail wagging the planning dog. Now, where should we start? Where we probably should start on this is to say, what's going to happen if you don't have a will? Where will your property go? And here we've got to divide your property into 2 separate parts. The first is what happens with respect to property: cash, stocks, bonds, real estate, that an individual owns outright in his or her name. And any property that an individual owns outright in his or her own name will pass at his or her death, if they don't have a will, through what are called the Intestacy rules. And every state has a whole set of rules as to whom property will go if there is no will. And this is the Virginia rule, and other states will differ. If you're not married, it'll go to a whole group of people, starting with parents, siblings, nieces, nephews, children, just a whole line. But if you have a spouse and no descendants, everything will go to the spouse that you own outright. If you have a spouse and descendants, in that case too, under Virginia law, but not under the law of every state, everything will go to the spouse. And if you have descendants and no spouse, it'll go to the descendants. And as I said before, if you're not married, you don't have kids, there are a whole host of other more collateral relatives to whom that property will go. But do remember that these intestacy rules only apply to property, assets that you own outright. There are a whole other types of ownership that will apply and decide where property will go. These are sometimes property that you might own jointly with somebody else. It's very common for a husband and wife to own property as joint tenants or as tenants by the entirety, in which case at the death of the first joint tenant, the property will pass automatically to the surviving joint tenancy. There's also a whole host of property types that have beneficiary designations, such as life insurance, retirement plans, individual retirement accounts, pay on death accounts at banks. In each of those cases where you've got a beneficiary designation, the intestacy rules will not apply. Instead, the property will pass according to the beneficiary designation. Wills only control, and everybody should have a will, but wills only control property that's owned outright by an individual at his or her death. It's not uncommon. In fact, we see it happen from time to time, that people may do a will in which they say, I'd like to leave everything to my children, but they find out because they're married and because they own all their property jointly with their spouse, such as bank accounts, their house, or they've named the surviving spouse as the beneficiary on retirement accounts and life insurance, things like that, that everything's going to go to the spouse despite what the will says. So a very important thing when you do planning is to know how the property is held and whether the will that you do will dispose of it or whether it'll be disposed of by some other instrument or contract other than the will, such as a life insurance contract or retirement plan, things like that. Now, when you talk about wills, and there are basically three types of wills that you will find when you look at estate planning. And these are the simple will, which is also sometimes called the sweetheart will. This is very common for many couples. And we're probably going to talk mostly about couples today, assuming you're married. But very common for couples. It's very simple. Sometimes it's called a sweetheart will. It's basically a will in which all of the property owned by the first spouse to die passes to the surviving spouse, if there is one. Or if there is no surviving spouse, all the property goes to the children. If you have minor children, then the will also name guardians for the minor children. Usually there are two different types of guardians. One is a guardian of the property who will take charge of financial matters for the child, manage any assets that the child receives from the decedent. The second is called the guardian of the person. And the guardian of the person is really an individual who will provide housing and shelter for a minor child and make sure they're taken care of that way. And it's not uncommon for the guardian of the person and the guardian of the property to be the same individuals, but that task or those responsibilities can be divided, if that makes sense, given that some people might be better at providing a home for minor kids, whereas other people might be better at managing the finances. The second type of will that you sometimes run into is called a complex will. And a complex will is one that has provisions for both non-tax planning, similar to the simple will, but also will have provisions in place to eliminate or minimize the exposure of the decedent to the payment of any taxes when he or she dies. because as we mentioned earlier, there are various federal or state taxes that might apply when an individual dies. So in a complex will, you see both tax planning and non-tax planning. They tend to be more complex because unfortunately, the provisions to minimize taxes can be more complex. Now, the third type of will, which is becoming more and more common in estate planning, quite honestly, they weren't that common when I started practicing 41 years ago, but they're far more common today, is what is called a pour-over will. And a pour-over will is one part of a two-part estate plan that also involves the use of what is called a revocable living trust. And in a pour-over will, the dispositive provisions, which tell where the property is going to go when a person dies, are not found in the will. They are actually found in the revocable living trust, which is essentially a document that an individual sets up. He or she is the trustee of that document. He or she can amend it and change the provisions at any time. But as we'll see in a minute, there are various advantages to using a revocable living trust as opposed to a will as the primary dispositive documents. But you have to have a will because you may not have transferred all the assets to the revocable trust by the time you've died. So a pour-over will basically transfers or pours over any assets owned outright by an individual at his or her death to his or her revocable trust that will contain the dispositive provisions. Now you may say, what are the advantages to having a pour-over will and revocable trust as to doing a simple will or a complex will? And here are some of the advantages to using a revocable living trust. One is privacy. One of the things people sometimes don't realize is that when an individual dies, his or her will be filed with the clerk of the local court in most states and open to public inspection. Anybody who wants to can come in and look at the provisions of his or her estate plan. And these days, with the clerk's offices becoming more computerized and the records becoming more computerized, an individual who is curious may not even have to go into the clerk's office to see what the will says. They can do it online. A second reason for using a revocable living trust is that they're lower administration cost. With a revocable living trust, if it is fully funded before a person dies, you may not have to go through court supervision of an individual's estate after he or she dies. This is sometimes called the probate process, but you may not have to go through it if all the assets are held in the trust. In many states, a revocable living trust will be more difficult under the law of that state to challenge than a will. Now, please note that a revocable living trust does not save any federal or state taxes. It's really designed more as a vehicle that may be advantageous in terms of disposing of a person's property at his or her death for the reasons that we have just discussed. Another reason for using a revocable living trust, quite honestly, is that it can provide for the management of an individual's assets. If the assets are held in the trust, and if the creator of the trust, sometimes called the settlor, the grantor, the trustor, there are various names by which this goes, if that creator of the trust becomes unable to manage his or her financial affairs, he or she will have named a successor trustee, and the successor trustee can step in to manage the assets without any need to change the title of the assets or the ownership. It can be a very expedient way, especially for older people, to provide for the management of assets in the event that they are unable to do so themselves. Now, we've already talked a little bit about how property can pass at death through beneficiary designations, such as life insurance, retirement plans, pay on death accounts, and the like. One of the things you have to do in your planning when you're doing is to make sure you understand right up front where the property, who owns the property. Because if the property is not owned outright, the beneficiary designation And the life insurance or retirement plans or IRAs or pay on death accounts will govern. And with jointly held property or tenancy by the entireties between spouses, that ownership will govern where the property goes, not the will. So be sure you know how property is owned. Otherwise, you might be in for a pretty rude awakening. Now, one of the basic questions that comes up from time to time, and it really is basic in estate planning, is how you want to leave property to the spouse, descendants, or others. Do you want to leave it outright so that the surviving spouse or the descendants or others have immediate control over that property, can do everything they want to with it? Or do you want to leave property in trust for the benefit of the spouse, the descendants, or others? Now, again, we're looking at this from a very high altitude, but there might be some disadvantages to leaving property outright to a spouse, descendants, or others. Because again, you may not want the surviving spouse to have complete control over the assets after the first spouse dies. May be perfectly appropriate. Some situations it may not. And the same thing for the kids. But let's talk a little bit about some of the reasons why you might want to use trust. We've just been talking about one of them. That is to maintain an element of control over the property. It may be that the first spouse to die wants to make sure that the surviving spouse will have the use and enjoyment of the property that he or she leaves to the surviving spouse, but wants to make sure that when the surviving spouse dies, the property will pass down to his or her children, and that the surviving spouse can't decide to give it to somebody else. You can also use trust as a way to designate the circumstances and purposes under which a beneficiary receives property. It may be that you only want the property that passes to a child to be used for their health, support, and education. It may be that you want to provide incentives to a child or other beneficiaries, saying that distributions may only be made if the child is earning money from gainful employment or is being a productive member of society. There are myriad ways in which to give instructions on how you'd like the property to be used. You can also determine who will manage the property. If you leave property to a child outright and the child is 21 or 25, many people do not think that child will be mature enough to manage the property appropriately and in a financially sound manner. In fact, we find many parents come in, and when you first meet with them when they're age 25 or 30 and they might have one or two young children, the parents will say, well, leave the property outright to the kids when they reach 25. And they come back 10 years later to revise their plans. And they say, well, we aren't quite sure about giving the money to the kids outright at age 25. Maybe 35 would be a better age. And by the time the parents reach age 55 or 60, they will tell you that when we revise our plan, we don't want those kids ever to have that property outright. We always want it to be under some form of control, although always available to them for their needs. So you can determine whether a child could be an appropriate trustee for his or her trust, another relative, a bank, and we'll talk about that in a minute or two. Handling assets and managing them from a financial perspective, it's not everybody's cup of tea. And it may be appropriate to have somebody else with some financial background manage those assets. Another reason for using a trust is to provide protection from creditors. Many people aren't aware, but if an individual sets up a trust for other third parties, children, spouses, whomever, under the laws of every state, unless it's waived, those assets will be protected from the claims of creditors. This could be somebody who got a judgment against a beneficiary of a trust. This could be a spouse of a beneficiary and they're getting divorced. Those creditors cannot reach the property in the trust. And in certain situations, a reason to use a trust is that it can be used to minimize taxes. It can be used to minimize federal and state taxes if you're going to be subject to that, because your asset base is large enough to possibly expose you to the imposition of federal or state taxes. Now, some other documents that you need to think about and should be part of a basic estate plan. One is a power of attorney. And there are really two types of powers of attorney that will avoid the need for the appointment of a guardian. And why would you want to avoid having a guardian appointed and instead use a power of attorney? The reason for avoiding the appointment of a guardian is that getting a guardian appointed involves a court, and that involves court supervision. Anytime there is court supervision, that adds expense, and it may add limitations on how and what a guardian can do with the property for the benefit of his or her ward. Now, there are two types of powers of attorney, and everybody should have each of these. One is a property power of attorney, and that allows the designated agent, be it the spouse, the kids, or a third party, to handle financial matters on behalf of an individual, to sign tax returns, buy or sell property, have access to bank accounts. And these days, that the power of attorney contains the appropriate information and appropriate provisions to gain access to digital assets, such as passwords and things like that. Because if you read the contract that all of us skip over when we sign up for different accounts like Google or Bing or whatever, it will say that the owner, be it Google or Microsoft, does not have to share and will not share information with anybody unless specifically authorized to. Power of attorney for property will allow you to do that. Second type of power of attorney is what's called a healthcare power of attorney. In Virginia, it's called an advanced medical power, advanced medical directive. And this allows the designated agent to make healthcare decisions on behalf of the creator of the power of attorney if the creator is unable to do so. And that can be very important, especially with respect to end-of-life decisions, whether you want food and water removed, as well as life support equipment, or whether you want to be kept alive for as long as possible. There's no right or wrong approach to this, but you want to leave instructions as to what will happen at the end of life if you're unable to provide those decisions. Now, sometimes you also want to have a living will. In many states, living wills in which you give end-of-life decisions as well are included as part of the healthcare power directive. In other states, they're separate documents, and you've got to consult with a lawyer or know what your state law is with respect to that. As I said before, states have different forms of property powers of attorney and healthcare powers and directives. And you really have to follow the rules in the states in which you reside. But please note that other states will accept a power of attorney or healthcare directive that is executed appropriately in the state in which you reside, even if you move to another state. But if you move to another state, get new powers of attorney and healthcare powers done. It'll just make life much simpler. Now, a question that many people often have is exactly who to name as executor or personal representative of a will, who to name as trustee, who to name as the agent under a property power of attorney, and who to name as the agent under a healthcare directive. You got a whole host of people you can choose, and it really depends upon their skills and whether you think they would be good at doing it. If you're married, the spouse is an obvious choice, though in some situations, spouses want nothing to do with handling financial affairs or dealing with children. Second choice would be children. Third is other family members. There could be non-family members such as friends or business partners who might be really good at handling the financial aspects. It's also possible to use a corporation, and there can be advantages and disadvantages to using a corporation. But one of the things to remember about corporate executors and corporate trustees is usually they've been doing it for a long time. They understand the rules, and they understand some of the complex tax and other issues that arise in the administration of an estate after a person dies, or the administration of a trust Now, one of the questions that many people often have about estate planning is what sort of taxes might apply. And when you think about this, there are basically three taxes that might apply. One is the estate tax, which is a tax on transfers at death. The second is the gift tax, which is a tax on transfers during life. And the third, which isn't known quite as well, is the generation skipping tax, which is a tax on transfers to grandchildren. In addition to these federal taxes, the estate tax, the gift tax, and the generation skipping tax, 17 states in the District of Columbia have separate state taxes that they impose on transfers at death. And these 17 states have laws that vary greatly from one state to another. You might ask, what are those states? The states are sort of clustered that have a separate state estate tax. All the states in New England, except New Hampshire, have one. Several states in the Mid-Atlantic, including New York, New Jersey, Pennsylvania, and Maryland, have a separate tax. Some of the Midwest states, such as Illinois and Minnesota, have a separate state death tax, and Oregon and Washington, out on the Pacific Northwest, have one. So if you reside in those states or have property in one of those states, you got to do some additional planning to accommodate those taxes. Now you might say, when does the tax apply? Well, right now, the tax doesn't apply to very many people. In fact, the estate tax right now probably applies to less than 1% of the people because of the exemption that federal law provides. Currently, that exemption is $10 million indexed for inflation. And the current inflation adjustment for 2021 is $11,700,000. That applies to each person, not to couples. And that basically means that a couple this year, if they have $23,400,000 or less in assets, they don't have to worry about paying an estate tax or a gift tax or a generation skipping tax. But there may be a problem. That $10 million exemption from the different federal taxes is scheduled to go down to $5 million indexed inflation in 2026. So if Congress does nothing at all between now and 2026, that exemption will be cut in half. Not only that, there are a lot of proposals in Congress right now in which there may be some additional changes. There may be some additional changes with respect to the estate, gift, and generation skipping taxes. For one, Senator Sanders of Vermont reintroduced a bill that he introduced 2 years ago that would reduce the exemption for estate tax and generation skipping tax from the current $10 million indexed for inflation to $3.5 million not indexed for inflation. He would reduce the gift tax exemption, which is the transfer on gifts at death, or excuse me, gifts during life, to $1 million not indexed for inflation. That's a substantial difference from the current $11,700,000. And if the exemptions go down, more and more people will be affected by the estate tax and have to do planning for minimizing or avoiding the estate tax. And think about it, most people don't realize it, but after a while, especially as you get older and you work longer, you can build up a fair amount of assets that will be subject to estate tax, because that would include assets that you own outright. The proceeds of life insurance on your life can be subject to estate tax. And these days, many of us build up large amounts in our retirement plans, such as 401k plans and individual retirement accounts. And all of the amounts are subject to estate tax. And if these amounts continue to go up in our different retirement plans, or we have a lot of life insurance and other assets do well, we own a house, and houses appreciate these days from time to time pretty rapidly in value, you could be subject to estate tax without realizing it. You got to do planning. And I should also point out that in those 17 states that have a state death tax, the exemption or threshold for tax is much lower than the current federal exemption. So you may have to plan for that. So a lot of planning that may need to be done. Now, there are various exclusions from tax. For example, individuals can give away $15,000 each year to any one or more individuals they choose to. And that means a couple can give away $30,000. Now, Senator Sanders has proposed capping the total amount that can be given away in a given year by an individual at $30,000. There are also unlimited exclusions from the tax on lifetime transfers for the payment of tuition for an individual at school and for the payment of medical expenses. Now, there's a catch to this, and that is that you've got to make those payments directly to the school or the medical provider. You can't give it to your child or other beneficiary and have them pay the expense. You've got to pay that provider directly. Now, two of the most important deductions. One is the unlimited marital deduction. Any amounts that you pass to a surviving spouse, either during life or at death, are not subject to gift tax on lifetime transfers or estate tax on transfers at death. So pretty much spouses can exchange property back and forth between each other. A second is an unlimited charitable deduction. Any amounts that you give to charity during life are not subject to gift tax, and that makes sense. And any amounts that you give to charity at death are not subject to estate tax. And if people have charitable intentions, one of the ways that they often minimize estate taxes, if they're otherwise subject to estate tax, is to give assets to charity. It can benefit the charity, it can benefit them from an estate tax standpoint, and it can be very, very beneficial. Now, a couple of other things to talk about before we move on and perhaps take some questions. One is, when you plan for charitable giving, one of the things you have to do is look at the different ways in which you make charitable gifts. An easy way, of course, is to give cash. But as Heather Engel and other people in the development office staff will tell you, another great way of making a charitable gift during life is to give stocks, especially appreciated stocks, because when you give appreciated stocks, you don't have to pay, or you avoid the payment of capital gains tax on the difference between the fair market value of the stock and your basis in the stock if you were to sell that, and you still get a full charitable deduction for the fair market value. It's a little bit of value added when you give appreciated property to a charity, such as the University of Virginia. Also, for people who may have charitable intentions, there are various ways of benefiting both charity and yourself. And it can help you get not just a gift tax charitable deduction, perhaps you do this during life, an income tax charitable deduction in some circumstances. And these can be very beneficial as well. We don't have time to talk about these today. They will certainly be the subject of a future program. But these are techniques you may have heard about, such as gift annuities, charitable remainder trust, in which a person sets up a trust for his or her own benefit and receives an annuity or other payment back during his or her life, and the balance will go to a charity, or charitable lead trust, which is the reverse, where a person sets up a trust. It'll make payments to a charity for a set number of years. Then whatever is left will go down to family members. And that can be a beneficial way of providing for the charity, also provide for family members, and minimizing your exposure to transfer tax. There are all sorts of things that can be done that we certainly don't have time to talk about today. Now, in terms of planning, you will think I will be promoting my self-interest, but please do consult with a lawyer when you're doing your estate planning. Doesn't mean you can't draft your own will, but all too often we see mistakes made when individuals draft their own will. You want to be careful with do-it-yourself programs. Because sometimes those do-it-yourself programs will work wonderfully. Other times, they may not catch the nuances of the law of the state in which you're residing at the time, which will govern whether that will or other document you draft will work. Many times they will, but just be careful. And the best thing to do is at least consult with a lawyer. We sometimes tell clients that it's a lot easier to have a will drafted correctly and a lot less expensive than it is to have a will or other estate planning documents fixed after a person dies because they weren't done correctly. Now, one question that I'm often asked is, okay, how do we find a good trust and estates lawyer, somebody who can help us with our will in the area in which we live? Now here, I'm going to put in a shameless plug for the American College of Trust and Estate Counsel. The American College of Trust and Estate Counsel has a website that's open to the public where you can search for a lawyer who is a member of the group on that website by just entering where you live, and it'll tell you who the members of the American College of Trust and Estate Counsel or ACTEC reside. Now, why do I recommend this? I simply recommend this because in order to join ACTEC, a person has to have been practicing for at least 10 years. The person has to practice at least 50% or more in the trust and estates field. And the lawyer has to have been recognized by his peers as being a person who is good and who contributes to the community and who will do a good job for clients. And the website for that is www.actec.org. So in conclusion, you all know, and we all know, that the current slogan for the capital campaign going on at the university, and I hope that each of you has contributed, is honor the future. Well, I would tell you that estate planning is a way that you can honor the future for your family or others by making sure that your property goes where you want it to go when you pass away or if you give property away during your life. So please honor your future by doing estate planning. Don't leave it for some other time, but if it's appropriate, please do it. And at this point, Heather, it's probably time to turn it back over to you to see if there are any questions out there that the attendees might have.
Skip, this has been wonderful. Thank you. And a number of questions have come in. Let's start with, what is the best way to set aside money for your kids in a trust?
Well, there's several different ways to set aside assets in a trust for children. And let's go through some of the options. One simple way, if you don't want to do a trust, is to set up what's called a custodial account, usually under the Uniform Transfers to Minors Act in each state. And this is an account in which there's a custodian who will manage the property, especially for minor kids, and disperse it for their needs, such as health, support, or education. Now, the problem with custodial accounts is, depending upon state law, those trusts have to terminate either at age 18 or age 21. And quite honestly, many parents do not think a child will be mature enough at age 18 or 21 to handle money outright. So that may not make the most sense. A second is a type of trust. Now, it's referred to by its Internal Revenue Code service number of 2503C. It's called a 2503C trust. It's a trust that you can make contributions to. The gifts will qualify for the $15,000 gift tax annual exclusion. Now, and that trust will have provisions so that the named trustee can distribute income and principal to the child or other beneficiary for his health, support, and education. Now, one quirk to the 2503C trust is that when that child or other beneficiary reaches age 21, the child is supposed to get the money outright. But you can actually do a provision in the trust that says you give the child the opportunity to get the money outright, but if they don't exercise that right within 30 days, then the money stays in trust until a more appropriate age of distribution, which could be age 25, 30, 35, whatever the parents think is appropriate. So that's another way of handling it. Now you might say, won't the child withdraw the property at age 21 when they're given that 30-day window to do so? And they may, but we've solved that problem by when the children are told that they have a right to withdraw the money, and it's usually in the office or meeting with the parents or anything like that. We say, okay, now if you exercise this right of withdrawal, by the way, if you do so, you're welcome to be a witness to your parents' new will, because they're ready to go next door and they're going to disinherit you in that will. And that's usually a strong enough incentive to the child not to exercise the power of withdrawal. Completely voluntary decision by the child, but that would probably work. And usually you don't have to use that type of means anyway. The third way is another type of trust where you can set up a trust for the benefit of several of your children. And this trust can run usually for as long as you'd like it to. And you can create these trusts. They're sometimes called crummy power trust, not because they're crummy in any way, but it's just the name of the case that permitted these types of trusts, in which you can set up the trust for one or more of your children. And again, qualify the gifts for the annual exclusion and have the trust last for a long period of time or for the life of the children. So there are all sorts of different ways to plan for the kids and benefit them. Another thing to think about too, depending upon why you want to set up or put money away for your children, is to use what's called a 529 plan. These are plans that exist in each state that allow you to, again, use your gift tax annual exclusion, put money in an account. It'll be invested for the benefit of the children, usually free of any federal or state income tax. And it can be used for educational purposes for the designated beneficiary. So it's a way that many parents or grandparents use for building up an education fund for the children or grandchildren very easily. And these can have some advantages because of their simplicity. You don't have to have a trustee, and the favorability that as long as the money is only used for education, and that can include to a certain amount each year, high school as well as lower school education, going up all the way through graduate school.
Thank you. Skip, can you stop sharing your screen so that our pictures on the screen can be a little bit larger?
Happy to. There we go.
Thank you.
That
Perfect.
better?
And we have gotten some questions about what the website was for ACTEC. And I will say that we'll just put that in our follow-up email that we send out to people. Can you talk a little bit about non-traditional estate planning, such as domestic partners?
Well, with respect to domestic partners, basically that's the same as planning for two single people. Unfortunately, under federal law, domestic partners and under state law too, do not get some of the advantages that married couples have, such as the unlimited marital deduction. So when you plan for a partner, the basic way in which you can minimize or eliminate any estate tax or gift tax is to take advantage of what is now the $10 million lifetime exemption. But remember, that exemption is scheduled to go down to $5 million in 2026 and may go down even lower if some of these proposals see the light of day. So when you plan for domestic partners, you're basically planning to take full advantage of the lifetime exemption, which also applies at death, that $10 million figure now. You often set up trust for the benefit of the partner. And there's some other techniques that can be used as well to minimize exposure, to tax on items such as life insurance, and you should consult with a lawyer on that. One other place where this can cause some issues is if money is held in retirement plans or individual retirement accounts. because again, with a domestic partner, they aren't treated under federal law for purposes as married. So you don't get the advantage of the marital deduction. And that can put some restrictions on designating a partner as a beneficiary of retirement assets in terms of how quickly those assets that the deceased partner leaves to the surviving partner, how quickly they have to be paid out. But the bottom line answer is you plan for domestic partners the same way you would plan for any other individual. And the basic tools for minimizing tax are making maximum advantage of the exemption and making maximum advantage of the gift tax annual exclusion.
So you just briefly mentioned retirement accounts in this answer. We have gotten a number of questions about retirement accounts and leaving a retirement account to a spouse. Do you have to leave it to your spouse? What if you want to leave it to a charity instead of your spouse, or can you leave it to your revocable trust instead of leaving it to your spouse?
Okay, that's 3 questions in one. So let's try to go through them. When you talk about retirement benefits, you first have to separate out qualified plans from individual retirement accounts. With retirement plans, you are obligated to leave at least a certain portion of a qualified retirement plan to your surviving spouse, unless the spouse waives that. Unless the spouse waives that. With individual retirement accounts, you can leave the full amount to the surviving spouse, no questions asked, and oftentimes the surviving spouse is the very best beneficiary as the recipient of qualified plans or as individual retirement accounts. And that's simply because the main thing you're trying to do with the benefits in a retirement plan normally is keep them in the plan for as long as possible so they continue to build up tax-free. Because when distributions are taken out of retirement plan, they're subject to taxation at ordinary income tax rates. Well, if you leave, let's just say, your IRA to your surviving spouse can roll over those amounts that he or she received into his or her own individual retirement account, and then they don't have to take distributions from that individual retirement account until they reach the required age for distribution, which right now is 72. There's actually a proposal pending right now. I don't know whether it will pass Congress to increase the age to 75 for required minimum distributions. So the best beneficiary of retirement plan benefits is the surviving spouse. There's no estate tax on the transfers to the surviving spouse, and the surviving spouse has the most flexibility to minimize his or her exposure to income taxes when withdrawals are made. Now, with respect to leaving retirement plan benefits or individual retirement accounts to charities, absolutely. The very best asset that can be left at death to which to leave a retirement plan is a charity. That's probably the best way to put it. Because there'll be no estate tax because of the unlimited charitable deduction. There'll be no income tax because charities are exempt from income tax. So you avoid all tax consequences whatsoever. That is the best thing to do. Now, with respect to individual retirement accounts during life, there are limits on which type of charitable or how you make a charitable gift using an individual retirement account. Basically, an individual who's age 70 and a half and older can give $100,000 a year out of his or her individual retirement account to a charity and get the benefit of an income tax charitable deduction, basically get the equivalent of an income tax charitable deduction. That's the best way. You can't do it with qualified plans. So during lifetime, you want to use an IRA. There is another proposal. It's just in Congress. Again, we don't know what's going to happen. So the people who've introduced it are very well respected. And the last bill they introduced on the same subject passed with bipartisan support in the House and Senate to allow everybody to make I think a $130,000 contribution once during life out of an individual retirement account. And that would be in addition to the people age 70 and a half and older being able to give away $100,000 a year. We don't know what's going to happen with that bill, but it was introduced by the ranking member of the Ways and Means Committee and the chair of the Ways and Means Committee. So bipartisan support for it.
Great, thank you. So here's an interesting fact pattern. My husband is listed as POD, so pay on death, for my financial accounts. And the same is true for me on his. Houses and car are owned jointly. We have executed medical directives. Finding an attorney to write up a will seems expensive. Putting the house and accounts in a trust seems like a pain. We just turned 50. How urgently do we need to work on our wills and trusts right now?
Well, this fact pattern actually refers to an example that we gave a little bit earlier, which is basically the situation in which the couple has used either joint ownership or beneficiary designations to control the disposition of the property at their death. The house will pass automatically to the surviving spouse because it's held in joint tenancy. The bank accounts sound like they're held on pay on death, so they'll pass automatically to the designated payee when the first spouse dies. And that'll work just fine as long as no other assets are owned outright by this couple. Now, I would assume tangible personal property, things such as books, pictures, automobiles, jewelry, are all owned jointly by the spouse. So there again, that will pass automatically to the surviving spouse. Retirement plans, if they have them, you'd have beneficiary designations that would control them. But the couple ought to make sure that that property or all the property they have is held jointly or has some sort of beneficiary designation. You'd hate for there to be a situation in which one of them owns some asset outright and they haven't done a will. Although in that situation, under the intestacy laws, it would probably pass outright to the surviving spouse, but you might have to go into court to get that administered. Now, here's the question for that couple. After the death of the first spouse, who owns all the property in his or her own name then? The jointly held property is owned in the name of that one surviving spouse. The pay on death accounts are now owned solely in the name of that one spouse. What's going to happen then? And the choice is, you can use the intestacy rules and it will pass under the intestacy rules, probably to your kids in the state in which you reside. And that's fine, but that probably will require some sort of court administration. Or you can go out at that time and get a will done and have the will govern the disposition of the surviving spouse's property when he or she passes away after the first spouse. And my personal feeling is, I don't know what state the questioner lives in, but it's a lot cheaper to do a will up front than to have to deal with intestate administration when the second spouse dies, or to deal with intestate administration if not all the assets are owned jointly or under some form of beneficiary designation or pay on death account.
You talk a little bit about when people move. So I do my estate planning documents in one state, and then a few years later, I moved to another state. Do I need to redo my estate planning documents?
And that's a good question. The basic answer is no. Each state will recognize a will or trust that is validly executed in another state. So if you do your estate planning documents in Virginia and you move, say, to North Carolina, there's no requirement that you update your wills and trust because of the move from Virginia to North Carolina. Now, I would say that even though a property power of attorney that you execute in Virginia in our example, or medical directive that you execute in Virginia in our example, will be valid in North Carolina and will be accepted in North Carolina. It's probably best to at least do new healthcare directives and powers of attorney, just so you've got the state form in place, because they'll be more accepted in North Carolina than a Virginia power might be. One of the strange things you find is that many institutions in one state start asking a lot of questions, or they get a little leery with respect to looking at out-of-state powers of attorney for property and medical directives and things like that. So it's always best to update at least the powers of attorney and medical directives. Now I'm going to qualify my answer on updating your estate plans. If a couple moves or an individual moves, well, I should say really if a couple moves from a state like Virginia, which is governed by common law, to one of the 8 community property states that has a completely different system of ownership of property between a husband and wife or between a married couple, you probably want to consult with a lawyer to make sure that you don't get tripped up by the differences between common law ownership in 42 states and the community property rules that you find in 8 states right now. It can cause some issues. And again, if you move from a community property state to a common law state or vice versa, it's probably best to at least look at your plan, have somebody examine it, and make sure it'll work the way you want it to, given the fact that the rules governing ownership of property by spouses are different.
So here's another question about property powers of attorney. Can a governmental agency or a financial institution choose to ignore a property power of attorney?
In most states right now, government institutions may try to ignore a property power of attorney, though I think it's hard for them to do so. It's validly executed, but every now and then you hear stories about them doing it. With respect to a financial institution, some financial institutions sometimes try to ignore a property power of attorney. They don't like the form or they have questions. However, under the laws of more and more states with respect to property powers of attorney, there are usually rules in there that say that if a financial institution wants to ignore a property power of attorney, they've got to explain why they're doing so within a certain amount of time, or they've got to accept it. So provisions have been put into laws in states like Virginia that basically say that a financial institution really has to have a really good reason for ignoring the property power of attorney, such as a question about the veracity of the signature or the execution, or whether the power of attorney contains the necessary provisions to permit the agent to do what he or she's asking to have done.
And we've gotten a few questions about divorce. What is the impact of a divorce on estate planning documents if you've gotten divorced and you haven't redone your documents?
Okay, the rules in most states say that if a couple gets divorced, upon the finalization of the divorce, the ex-spouse is no longer a beneficiary under the will or usually under any sort of revocable trust. But you want to check that on state law. Also, in some states, not all, if you've designated the spouse as a beneficiary of life insurance on your life, a divorce does not remove the ex-spouse as a beneficiary of the life insurance. Now, every divorce attorney is aware of these rules, and usually in the divorce settlement, they will take account of life insurance, what needs to be done with retirement plans, other types of jointly held assets, to make sure that the ex-spouse will have only what ownership interest he or she's entitled to under the divorce agreement. In getting divorced, however, there's often a long period between when a couple separates and when they get divorced. And we think, this is just some practical advice, that if you're in the process of getting divorced, you've separated, you're not going to get reconciled, or it's unlikely that there'll be a reconciliation. An individual ought to redo his or her estate plan to remove the soon-to-be ex-spouse as a beneficiary. They ought to look at the retirement plans to see what can be done. They ought to look at the life insurance to remove the soon-to-be ex-spouse as a beneficiary, just to make sure that they clear the decks during that period between when the separation occurs and when the actual divorce occurs. But again, you should always consult with your divorce attorney before you take any steps. And a lot of this too will depend upon the nature of the divorce, whether it's an amicable divorce or whether it's a hotly contested divorce. But the other thing the couple or each person probably wants to do at least is redo their powers of attorney to remove the soon-to-be ex-spouse as an agent under the property power of attorney and as an agent of the medical power of attorney. We've seen many situations in that period between separation and divorce in which the soon-to-be ex-spouse has gone in using the power of attorney and raided the bank accounts and done other things like that. Saw one situation in which a person was essentially wiped out because the soon-to-be ex-spouse basically used the power of attorney to take every asset that the ex-spouse could get the ex-spouse's hands on.
Well, I know we're a few minutes over, so I'll ask you one more question and then we can wrap things up. We have a few people who are looking for insights into special needs trusts, whether they're for adult children or a parent or a sibling. So can you talk a little bit about special needs trusts and what purpose they serve?
Special needs trusts can be used basically for any disabled beneficiary from a child through an adult, although they're primarily used for disabled children, but that includes adult children. One of the things you have to look at when you use a special needs trust is there are various restrictions with respect to their use and how they're drafted and what access the beneficiary will have. There are also other ways in which trusts can be drafted for the benefit of an individual who has special needs without having to meet the strenuous requirements of special needs trusts. And the whole purpose for using a special needs trust or using some other type of trust is basically to make sure that the beneficiary assets in that trust cannot be seized essentially by the government to pay for services that the federal or state or local government's providing. A special needs trust using the form that governs those can be appropriate, but there are other types of trusts that can also be used to ensure that the benefits remain in trust are available to the special needs beneficiary without possible seizure by the government to pay expenses of services the government's providing. And we could do a whole session on these because there are all sorts of variations and rules with respect to them.
Well, then that leads me to my next topic. So Skip, thank you so much for your time and for doing this today. I'd like to thank everyone for participating. We have had a lot of interest in financial planning and legal planning webinars, so there will be more of these coming out in the next few months. And there's going to be a follow-up email going out to all of you that will have the Office of Gift Planning contact information in it. We have a new will planning guide that we would like to share with you, so you can just email us and we can send that out to you. If there are certain topics you'd like to learn about, again, just email us and let us know. And we will also send a link to the recording of today's event. So thank you, everybody. Thank you to our viewers, and Skip, thank you for your time. And thank you for all of the fabulous UVA staff that helped with the technical aspects of this, because I can tell you the gift planning team could not have handled the technology of getting this up on Zoom for everyone to watch. So thank you and have a great day.